If you've just secured a $2 million verdict or settlement for your client, you should be celebrating. But what if, after collecting the judgment and dispersing the net settlement proceeds, 45 days later, your client calls you in tears because Medicaid has just sent a termination letter, SSI payments stopped, and their medical coverage is gone? The case is over. You thought you did your job. In the client's eyes, there is still a big problem, and they find you to be responsible for it. I'm Joanna Wines, a former trial attorney turned settlement consultant. I partner with law firms nationwide to make sure that this exact nightmare never happens to you or your clients. Today, I'm going to break down the compliance rules that trigger SSI and certain types of Medicaid loss after a verdict, how one small oversight can dismantle a multi-million-dollar result, the exact process I use to protect verdicts and settlements and benefits before the check even clears. SSI and certain types of Medicaid are means-tested benefits. The federal asset limit for SSI is only $2,000 for an individual or $3,000 for a couple. It is not indexed for inflation. It's not forgiving. If your client has more than $2,000 in countable assets, even for a single day, benefits can be terminated. And here is the kicker. Countable includes cash, check savings balances, stocks, most investment accounts, and the net proceeds of your settlement or judgment. Most states run automated monthly bank sweeps to detect balances over the limit. Federal rules require the clients to report any change in resources within 10 days, and the failure to do so can trigger overpayment penalties. So if a client deposits $1 million into their personal bank account without a plan, their benefits are gone, their medical care is disrupted, and the administrative re-enrollment nightmare begins. I want to tell you a little bit about a real case scenario. There was a premises liability case with a brain injury to a 14-year-old girl. The child was receiving SSI and Medicaid-funded in-home therapies, as well as attendant care. The attorney achieved a $1 million gross settlement. Net to the client after fees and costs was $620,000. Here's what happened. The settlement check was deposited directly into a blocked minor's account in the child's name. Then, bank reported the balance to the state benefits agencies. Automated systems flags the child as over the asset limit. SSI and Medicaid eligibility are terminated within 30 days. So what happened here? The child lost access to daily therapies and in-home support. Medicaid coverage for $38,000 a year medication stopped. The mother had to privately fund services while pursuing reinstatement of these government benefits, a process that took 11 months. Why does this happen? It's not necessarily a mistake that you made in litigation, but there is a gap when it comes to bringing the litigation into the next chapter and creating a new life for the beneficiaries. It's a gap in settlement planning. Key triggers for SSI and Medicaid loss after a large verdict can include failures to use a special needs trust or other exempt vehicle, the improper titling of accounts if the funds are in the client's legal name, they count as assets, timing errors. Even if a special needs trust is set up, benefits can be lost if first it's deposited into the personal account of the client. Misunderstanding exempt assets. Primary residence may be exempt, but buying one without planning can still trigger income counting in certain states and under certain circumstances. Here is how I work with attorneys to make sure that this never happens. Review client's benefit status before resolution. Identify all means-tested programs, including SSI, Medicaid, SNAP, Section 8, that they are currently on, and also what they may need to apply for in the future. Document state-specific asset and income limits. Also, let your client know throughout the litigation, if they have these benefits, that they will need some sort of protective mechanism at the time of settlement if they'd like to keep these benefits intact. It's really, really hard when a client goes through their entire litigation thinking that they're going to get a lump sum check, and then they find out at the end of the day that they need to do a special needs trust. It's better to set the expectations early. So after you do your pre-settlement planning, then we get to settlement planning. My settlement plan includes meeting with the clients to review their benefits, their needs, and their goals. I determine whether the client is on any means-tested benefits that they'd like to preserve. Myself and my team will provide various options to protect settlement funds via a special needs trust, ABLE account, spend down, or a combination thereof. We can determine whether they'd like to utilize a structured settlement for a portion of their settlement proceeds, and to help determine how to allocate between funds liquid in the trust versus periodic payments, otherwise known as structured settlements, going into the trust over time. We coordinate with a special needs trust trustee or pool trust administrator. We help provide any necessary release language to the extent that a structured settlement may be paying into a trust. We also ensure that your firm is aware of the trust funding language in order to distribute the funds directly into the special needs trust, bypassing personal accounts entirely. With respect to compliance and communications, we make sure that we alert the trust company as to the various means-tested benefits of your client so that they can ensure appropriate distributions and reporting. We provide client education on ongoing trust compliance. We keep copies of all correspondence in case of later disputes or issues. We also, if your client decides that they do want to take a lump sum and they are willing to take that risk of losing their benefits, we can provide your law firm with a government benefits waiver that your firm might have the client sign so that you know that you're protected and that you did your part. Final case closeout, we will provide your firm with an executed copy of the special needs trust, proof that the client's benefits remain intact. We also offload all the benefits and distribution-related calls from your paralegal team. Why does this matter for your firm? Without this process, your multi-million-dollar verdict or settlement can become a PR headache. It can trigger malpractice fears, or it can turn your staff into unpaid benefit caseworkers. With our process, your client is protected, your case closes cleanly, and your name stays tied to a success story, not a crisis. If you handle high-value settlements in family law, employment law, or civil litigation, and you want to end the case without creating a new one, let's talk. In 20 minutes, I will walk you through exactly how we protect public benefits eligibility, increase client outcomes by 200 to 400% through structured settlements, remove 10+ hours of post-settlement admin from your team. Click the link below to schedule. I'm Joanna Wines, protecting your client and your firm every time.